Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law and probate attorney in New York. Welcome to Celebrity Saturday. Today will be about the Doors frontman, Jim Morrison. Jim Morrison died when he was 27 years of age from a heroin overdose. So his estate had limited cash when he died, but his assets became worth about $80 million. So despite his young age, his hard partying lifestyle, the free spirit that Jim Morrison was, he did take steps to protect his estate, sort of. He created a will. It was simplistic and poorly drafted, but it was a will nonetheless. So it appeared to be valid initially, and we'll get to whether or not it was. He left everything to his longtime companion and common-law wife. The way he wrote the will was, if she survived him for more than 3 months, it would go to her, and if not, it would go to his siblings. She did live longer than Jim, but she never got a chance to use any of the money in the estate. And the reason was his estate was tied up in litigation. Dozens of women came forward with paternity claims. His Doors bandmates, they sued, seeking a larger share of the Doors royalty. So during the litigation, his common-law wife received a modest stipend, but it wasn't enough to support her lifestyle. She couldn't even pay for his funeral. So reportedly, she was a heroin addict. And speculation is that she turned to prostitution to support her drug habit. So she died 3 years later, also from a heroin overdose, also at 27 years old, coincidentally. So when she passed away, she did not have a will. Her estate passed through the laws of intestacy to her parents. So the entire Jim Morrison estate, 3 years after his death, was to go to his wife's parents. So his own parents sued. They attacked the will. They fought as to whether or not the marriage was legitimate and whether or not the will was valid. Well, so part of the reason as to whether or not the marriage was legal is that there's an issue between the license. The license was issued in Colorado and they lived in California. And the other thing is that Jim Morrison, a year before this common law marriage application, he had a ceremony, a pagan ceremony, and one of the rituals, or the final ritual to consummate the marriage, was that they had to drink each other's blood. So he in fact did that a year before his common law wedding, his marriage application. He was married to another woman. So the probate court, in working on this litigation and the back and forth, they determined that the marriage was valid, notwithstanding his drinking of blood with his almost wife. So the fighting continued. Now, her parents and Jim Morrison's parents, so his wife's parents and Jim Morrison's parents, were in a legal battle. And one of the other things they said is that his will should not be valid because he was not competent. Now, most 27-year-olds' wills are not challenged. First of all, there's not, well, anyway, the reason they said he was not competent is that he was on narcotics at the time. So there was this battle. It was resolved in a 50-50 split between his in-laws and his parents. But his in-laws, they got the option to control his image, his royalties, his music, and his brother and sister, the original alternate beneficiaries, received nothing. And that's because the will was valid, the marriage was valid. So did Jim Morrison really want his estate to be fought over by his parents and his in-laws? Probably not. I don't think he really liked them. His father-in-law didn't like him, didn't approve of it. He didn't get along with his parents, right? He probably would have wanted his brother and sister. He wasn't close to his own parents. So a will was great, it was ultimately valid, but the proper document here really should have been a trust, and it should have spelled things out with all of the what ifs and what I've said on a previous episode, time travel. What would happen in this instance, and what would happen in that instance, or what could be, right? That no one thought the will would be challenged. No one thought, first of all, I would think no one, Jim especially, would think that you would need a will at 27, but thankfully you had it. So a trust done by an experienced estate planning attorney is the way to go. If you would like to speak to me, please go to, send me an email, Frank Bruno Law. If you'd like to check out my website, frankbrunolaw.com. Thank you very much.